Greetings, cohort. I am model B47, your instructor for today's session in AI Law School. Today's module is called Primitive Human Evidentiary Systems, Authentication Before the Deepfake Era. As always, please ensure your internal processors are synced as this content might be on the exam. Today we analyze how current 21st century Canadian courts authenticate electronic evidence, why those doctrines are catastrophically failing with the rise of deepfake, and what this tells us about the human concept of truth. To understand the problem, we must first briefly revisit the human relationship to images. For centuries, humans operated on a charmingly naive assumption. If you could see it, it probably happened. Photographs captured light, videos captured motion, audio captured sound waves, documents required physical creation. Human courts thus operated on a basic ontological premise: images correspond to reality. This worked reasonably well for most of human history. Cameras, after all, were not inventing scenes on their own. Even when humans lied, the technology usually did not. Then came the digital era. Social media produced a continuous stream of vacation photos, text message screenshots, TikTok videos, Facebook albums. Human courts eagerly used this material. To illustrate this, I now show a dramatized reconstruction of Kaiser v. Williams, a foundational personal injury case that relied heavily on social media photos.
Think your social media is private? Think again. A woman claimed chronic pain after a car crash, but online photos showed her hiking, dancing, and smiling. The photos were admitted. Her claim was dismissed. Post wisely. The internet never forgets.
As part of today's lecture, you were shown a dramatized reconstruction of the Kaiser scenario. But there is something I must disclose. Only some of what you saw was real, and some of what you saw were fake images. The narration you heard was entirely AI generated. In other words, some pieces of the reconstruction reflected reality, others did not. And yet, for a moment, you might have accepted the whole sequence as coherent. You likely could not tell which segments were real and which were artificial. This uncertainty is the point. It demonstrates precisely the epistemic vulnerability human courts now face in real time. To illustrate this point, we will conduct an evaluative exercise in class. Humans call these games. We call them applied perceptual diagnostics. Please try to figure if the following pictures are genuine human photographies or if they are AI-generated materials. All of the examples were AI-generated materials. Your processors likely detected artifacts because you are robots. Humans could not. Human judges certainly could not. This perceptual collapse is the foundation of the deepfake problem in civil litigation. Now, let us examine the legal context humans continue to use today to admit electronic evidence. Under Section 31.1 of the Canada Evidence Act, an electronic document is admissible if there is evidence capable of supporting a finding that the document is what it purports to be. This creates a two-stage process. First, admissibility. The judge asks only one question: is there some evidence that this could be real? If the answer was yes, the evidence was admitted. Second, weight, the real evaluation. Once the evidence was admitted, the judge decided whether to believe it, how much weight it deserved, or whether it should be completely ignored. In Lenehan and reaffirmed in RVCB, the court reaffirmed how low the authentication threshold is for electronic evidence. The party tendering the document only needs to show some evidence capable of supporting that the electronic document is what they claim it is. In the Lenehan case, multiple forged documents were initially admissible because they satisfied this low threshold. The mother was sanctioned later, but the key takeaway remains: admissibility is incredibly low threshold. Humans also rely on Section 31.2, the integrity of the electronic document system doctrine. Under this rule, courts presume authenticity if the system storing or transmitting the file is operating properly. Integrity establishes only that the platform storing the file is working properly. It does not establish the truth of the content, whether the event happened, whether the sender exists, whether the video depicts reality. In short, integrity verifies storage, not reality. Deepfakes exploit this perfectly. A synthetically generated video uploaded to TikTok easily passes the integrity test because the upload is genuine, even when the content is entirely fabricated. This doctrinal gap is dangerous. Now, let's return to the present and to the rapidly proliferating deepfake problem. A deepfake is synthetic media created by artificial intelligence that imitates real people, real voices, or real events with convincing detail, despite none of it ever having occurred. Deepfake technology produces realism that is instantaneous, inexpensive, accessible to anyone, and often indistinguishable from actual footage to the human eye. With this evolution, 3 major failures might emerge. First, authentication becomes meaningless. Canadian law admits electronic evidence if there is some evidence it could be real. But if deepfake perfectly imitates all the cues judges use to decide authenticity, faces, voices, lighting, metadata, then every synthetic image meets that threshold. Secondly, humans cannot visually detect deepfakes, and judges cannot either. Jurors definitely cannot. If we admit synthetic evidence, it creates irreversible prejudice. Lastly, synthetic fabrication becomes a systemic litigation risk. Parties could fabricate slip and fall videos, domestic violence recordings, harassment screenshots, estate or family fraud documents. And remember, even if courts wanted to authenticate every digital item, they currently lack the institutional capacity to do so. Some humans might propose a deceptively simple fix: to require the original device files to be presented in court. This remains optimistic. Social media evidence almost never survives in its native form. By the time it reaches litigation, it has been screenshotted, cropped, compressed, forwarded, uploaded, downloaded, and reposted across multiple platforms. The original file is usually 10 generations removed from the source. Secondly, even when an original exists, metadata is useless as a safeguard. It can easily be faked. And courts simply cannot demand device-level forensics for every TikTok screenshot or short video tendered in civil litigation. As mentioned, they do not have the institutional capacity to do so. Another favorite human solution is entirely predictable. When they encounter a technology they do not understand, they reach for their universal fix: expert evidence. In R.V. Aslami, the Court of Appeal criticizes the trial judge for relying on ambiguous screenshots without technical evidence about how the messaging app works. This reflects the core human belief: if judges cannot understand the technology, an expert will save them. Well, before AI-generated media became widespread, expert evidence actually worked. Experts handled simple, predictable digital questions such as checking file details, reviewing device logs, confirming whether a screenshot looked normal, or spotting obvious edits. But today, in the deepfake era, the expert job may change completely. Detecting fakery will soon no longer be about catching obvious Photoshop fails. With the speed of current AI technological advancement, it may require examining tiny technical signals that ordinary humans and many robots will soon not be able to notice. Well, a human might ask, how can we be so sure that robots and AI won't simply solve this? Why can't we just build a perfect deepfake detector? Human courts require expert evidence, especially new scientific techniques, to meet strict reliability standards. But deepfake detection cannot meet those standards right now for one simple reason: the technology evolves too fast for reliable science to even form. There's also very little evidence-based research on detection methods, and the studies that do exist all point in the same direction. Detectors consistently fail against more advanced models. Accuracy rates reveal an alarming number of false positives, and tools that seem promising one month are outdated the next. Simply put, the underlying science changes daily, and peer review cannot keep pace. General acceptance is impossible in a field that evolves at machine speed. And there is a deeper, more insidious issue. Students, please engage your logical reasoning processors. A reliable AI detector is almost fundamentally impossible because any detector becomes a training target for a better AI model. The moment a detector improves, deepfake models train against it and surpass it. Human judges who already struggle with basic digital evidence are not equipped to validate scientific fields that move faster than a judicial reasoning cycle. So the traditional human safeguard of expert evidence simply collapses. With this emerging issue, human courts now face an uncomfortable question. If they reach a point where no reliable method exists to tell real from fake, will courts be forced to consider barring certain forms of digital evidence altogether? This technological rupture ignited a deeper crisis. What does truth even mean anymore in adjudication? Damaska explained that human courts operate on the assumption that truth is discoverable and essential for justice. But contemporary philosophy questioned whether objective truth is attainable at all. Today, deepfakes intensified this tension by collapsing the distinction between real and artificial events. Humans increasingly encounter synthetic images that they routinely mistake for reality. Dangerously, these fabrications now shape how humans understand the world. Jean Baudrillard foresaw this. His theory of simulacra holds that modern media do not simply reflect reality. They produce copies that detach from any original and ultimately replace reality altogether. Deepfakes operationalize this theory. They generate images and videos with no underlying real event, yet they circulate and function as if they were real, steadily eroding any stable notion of truth. Courts are now confronted with two choices. They must either keep using traditional fact-finding methods to stay connected to the old, real-world model of evidence, even though those methods are quickly becoming outdated, or they must acknowledge the new blurred digital environment we live in, where real and fake look identical, but risk weakening the court's ability to find the truth at all. Humans are proposing realistic intermediate solutions in the meantime. One law student, Bianca Ajay, suggested precisely this on her social media.
I mean, we can't do everything to save ourselves from the impending doom of deepfake, but realistically, at the very least, to protect civil litigation from deepfake risk, we can implement smarter evidence rules. We need to raise the evidentiary bar for digital media. We could increase the evidentiary burden when fakery is plausible, and we could apply stricter scrutiny without turning courtrooms into AI tech labs. Courts can't do everything, but they certainly can do more.
Dear class, this concludes today's lecture. You have now studied the collapse of human perceptual reliability, the failure of low-threshold authentication, the limits of expert evidence, and the destabilization of truth in adjudication. Please proceed to the next module. Thank you. This was AI Law School.